Welcome to K&L Gates Working Wise podcast series. My name is Bridget Blinn-Spears, and I'm counsel in the Raleigh office of the firm's Labor, Employment, and Workplace Safety practice area. In this podcast, I will discuss considerations for employers as marijuana laws continue to evolve around the country, despite ongoing federal criminalization of marijuana sales and possession. A growing number of states have legalized medical marijuana use. Employees in these states may ingest or smoke marijuana as part of treatment for a wide variety of medical problems, from seizure disorders to glaucoma to anxiety. For purposes of this discussion, legalizing medical marijuana use does not include states with laws solely legalizing cannabidiol or CBD, which is not psychoactive and is used specifically for treatment of epilepsy or seizures in seriously ill children. Common tests that pick up marijuana use do so not by identifying THC itself in an employee's system, but rather by identifying a byproduct of the liver processing the drug, an effect that can linger for weeks after use and long after any impairment has subsided. Employers cannot rely on those tests to determine whether employees are impaired at work. Not all employers choose to test for marijuana in standard screening panels, particularly since the test results provide no information about impairment at work. Others are faced with navigating test results that provide an incomplete picture of their employees' use of the drug and no information regarding whether it is impacting their work. Employers who continue to prohibit marijuana use in states where employees may be legally using marijuana under state law will need to develop other evidence to pair with test results, documenting observed behaviors consistent with marijuana use, such as odor or smell of smoke, red, bloodshot eyes, unwarranted silliness or laughter, strongly increased appetites, foggy or slow memory, increased tendency to chatter or be overly sociable, lowered inhibitions, impaired judgment, dizziness or sedation and slow movement, or lethargy and lack of activity would be paired with test results to support terminating employees for using marijuana on the job. Several states have language indicating that marijuana should be treated like any other prescription medication, particularly for purposes of medical procedures like organ transplant qualification. Arizona, Delaware, Illinois, Minnesota, New Hampshire, and New York have this statutory language. Some states explicitly prohibit employers from discriminating against qualified marijuana users because of their off-duty marijuana use, unless doing so would place the employer in violation of federal regulations or put in jeopardy federal funding. Arizona, Connecticut, Delaware, Minnesota, New York, Pennsylvania, and Rhode Island prohibit such discrimination explicitly in their state laws. Massachusetts does not have explicit statutory protection from discrimination, but in July of 2017, the Massachusetts Supreme Court ruled that employers may have a duty to reasonably accommodate off-duty medical marijuana use. The plaintiff in that case used marijuana in the evening 2 to 3 times a week as treatment for her Crohn's disease. Her employer terminated her employment when she tested positive for marijuana, as she had told them she would, on a routine drug screen. The employer stated that the drug remained illegal under federal law and that they followed federal instead of state law. The court determined that because the law treated medical marijuana the same as other prescribed medications, the employer had to engage in the interactive process to determine whether permitting off-duty use was a reasonable accommodation. The court also noted that since the statute explicitly noted that employers were not required to accommodate on-site consumption of marijuana, it implicitly recognized that off-site consumption might be a reasonable accommodation. A court in Rhode Island recently reached a similar conclusion. Several other states that have legalized medical marijuana have language like Massachusetts that explicitly states that employers need not accommodate medical marijuana use on-site or otherwise tolerate impairment at work. Alaska, Arizona, California, Connecticut, Florida, Illinois, Massachusetts, Michigan, Minnesota, Montana, Nevada, New Hampshire, New Jersey, Ohio, Pennsylvania, and Rhode Island have similar statutory language, allowing employers to prohibit medical marijuana use at work. Courts in these states have not yet addressed whether their statutory language implicitly suggests that off-duty use should be considered as a reasonable accommodation. But employers should anticipate that employees will leverage the decision in Massachusetts to support this argument. Courts in Colorado, New York, and California have confirmed employers' rights to terminate employees for marijuana use. Several states have also legalized recreational use of marijuana, and more continue to do so. Some limit distribution to state-licensed dispensaries, and others permit users to grow a personal supply at home. Washington, Oregon, California, Colorado, Massachusetts, and Alaska all have laws that permit personal recreational marijuana use. And voters in Maine recently passed a referendum approving recreational use as well. The governor in Maine promised to veto, but it seems likely that recreational marijuana will be legalized in Maine sooner rather than later. Several states have laws restricting employers from discriminating against employees for their off-duty use of lawful products. Illinois, Minnesota, Missouri, Montana, Nevada, North Carolina, Tennessee, and Wisconsin have such laws. 4 others protect employees who engage in lawful activities: California, Colorado, New York, and North Dakota. Recreational use of marijuana outside the workplace may be protected lawful activity or use of lawful products in states where those who are protected. Employers in those states, currently California, Nevada, and Colorado, should be particularly cautious in taking action against employees who fail drug tests for marijuana use that occurred off-duty. This does not prevent employers from prohibiting employees from using recreational marijuana while they are working. Employers who have explicit state law duty to accommodate medical marijuana use should amend their policies to treat medical marijuana equally with prescription drugs. Technically, physicians certify patients as qualified medical marijuana users rather than prescribing marijuana, which they're prohibited from doing under the Controlled Substances Act. Employers should then use the same interactive process to work through accommodations and undue hardship analysis with each employee who discloses medical marijuana use. Thus far, employees and advocates have focused on protecting off-duty use, but in jobs that are not safety sensitive, as marijuana use becomes more common, it's likely that employees will argue at some point that on-duty use is also a reasonable accommodation. In either case, employers should resist the temptation to substitute their judgment for that of their employees' medical providers. Rather, they should work through the documentation process to make sure that employees who are prescribed medical marijuana or who are certified as qualified users can perform the essential functions of their job without danger of harm to themselves or others. This assurance can be obtained from employees' medical providers, and employers should not undertake to make the determination themselves. Employers should also be prepared to assess whether permitting off-duty marijuana use poses an undue hardship. For employers whose federal funding would be at risk if they permit employees to use marijuana, the undue hardship analysis may be relatively simple and easily defended. For employers who are not federal contractors or otherwise subject to specific regulations, like the employer in the recent Massachusetts case, it may be more difficult to argue that an employee's off-duty use causes an undue hardship in the workplace. Federal law continues to prohibit selling, buying, or possession, thus also growing, marijuana through the Controlled Substances Act, except for narrow exceptions for research. However, the 2014 Rohrabacher-Farr Amendment, added to a budget bill during the Obama administration, prohibits the Justice Department from spending federal money to prosecute medical marijuana sellers and users who are operating legally under state laws. Additionally, neither the U.S. Supreme Court nor any other federal appellate courts have determined that off-duty medical marijuana use can never be a reasonable accommodation. Even before the amendment, recognizing that many states are legalizing marijuana use, the Department of Justice determined to rely on state law enforcement authorities to manage areas that are not federal priorities. Federal government enforcement has been focused on 8 areas of primary concern, namely, preventing distribution to minors, revenue from flowing to criminal enterprises, gangs, and cartels, diversion from states where marijuana is legal in some forms to states where it is not, state-authorized activity from being used as a cover or pretext for trafficking other illegal drugs or other illegal activity, violence and the use of firearms and cultivating and use of marijuana, drug driving and exacerbation of other adverse public health consequences associated with marijuana use, growing on public lands and attendant public safety and environmental dangers, and possession or use on federal property. Thus far, the Trump administration has not interfered with well-regulated marijuana programs. Polls suggest that 70% of the U.S. public supports allowing states to determine marijuana policies without federal intervention. The U.S. Congress has considered legislation that would prevent federal interference in state marijuana policies in the summer of 2017, and legislation has also been circulated that would take marijuana out of the Controlled Substances Act. Thus far, these measures have not been successful. Notably, Attorney General Jeff Sessions has been very critical of laws legalizing marijuana and has publicly pressured Congress to roll back the protections offered by the Rohrabacher-Farr Amendment. Thus far, the amendment had not made it into the House version of the budget bill currently under consideration, but it was in the earlier Senate version. It has bipartisan support, but some strong opposition from some Republican lawmakers. Federal contractors and other regulated employers must continue to follow federal law. As marijuana laws evolve, employers who are not subject to federal funding or specific regulations are grappling with whether to choose to accommodate employees' medical use or recreational use of marijuana. Human resources and management professionals responsible for developing policies and handling issues that arise with respect to accommodation should be clear on the company's status as a government contractor or subcontractor and on any federal regulations that might affect the undue hardship analysis. Policies should directly address marijuana use. In states where marijuana is illegal, companies should be sure to explicitly include marijuana in their policy to avoid confusion. Companies with a potential duty to reasonably accommodate, or who choose to do so voluntarily, should include medical marijuana in the section of their policies addressing prescription drugs. And because this area of the law is rapidly changing, it's important to monitor changes in all states where your company has employees and in federal legislation or enforcement priorities. We hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice group on our main website, klgates.com. Thank you for joining us.